How can I express my gratitude?
How can I express my gratitude
for all the many things,
you've
Father, you done for me, yeah.
Words are not enough to say thank you.
So Lord, you are,
Lord,
you are.
you're my everything.
See, I call you Jireh.
Lord, my provider.
I call you Nisi. You are my battle. I call you Rapha. Hey.
You are my healer.
Say, Lord, you are.
Lord, you're my everything.
I call you Jireh.
Call you Jireh. Lord, my provider.
I call you Nisi.
Nisi.
You are my battle. I call you Rapha.
You Rapha. You are my healer.
Say, Lord, you are.
Lord,
You are.
you're my everything.
Uya matinyana. Uya matinyana. Uya matinyana. Oh, uya matinyana. Yeah, so uya.
Moya matinina. Moya matinina.
Yeah.
Moya matinina.
Oh, uya matinyana. Say, I call you Jireh, say,
I call you
yeah.
Lord, my
I
provider.
call you Nisi.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Check the green screen out. Green screen. Hello, and another wonderful Saturday is with us. Well, we're a little late, but better late than never. My name is Oreku Fripon, and I have the duty and the honor to be hosting this program, The Community and the Law, brought to you by BWF Solicitors. BWF Solicitors, 4th floor of the Honor House, 214 to 218 Tottenham High Road, Seven Sisters, North London. They work Monday to Friday between 9 and 6 p.m., 9 in the morning and 6 p.m., I should say. And they deal with all the community law issues, whether it's an immigration issue, whether it is about understanding the law, the updates that come from the Home Office and all the other bits. And they also help you make your application so you can do that successfully. Once again, it's a Saturday afternoon, and we are here to bring you another very wonderful discussion. We have some updates to give you, and again, we also have a question we will all be putting our minds to see how well we can answer that. So let me first of all quickly introduce my guest, who is a lawyer, a solicitor from BWF Solicitors, our sponsors. And Charles Asma is going to help us unravel and answer the question how to successfully take away that condition that is known as no recourse to public funds. How you can successfully take that off your visa condition. How we're going to do that, we'll tell you. How you can do that successfully, we'll tell you. And how you can make mistakes, we'll tell you so you avoid that. Lawyer Charles Asma is here. Lawyer, good afternoon, and thank you for joining us on another Saturday afternoon.
Good afternoon, Bragoku.
How are you doing?
Very well. How are you too?
Good. We're back, and like in the classroom, we are in for clarification, new lessons, and of course, new steps to follow when it is that we are facing our immigration conditions. So I thank you for your time, and we'll come back to you. But ladies and gentlemen, let us first of all look at what updates we have had earlier in the week. Remember, there is this situation where people find it difficult paying the application fees and the rest of it. Can we ask the government to pay our application fees for us? Now, listen to this. All immigration applicants will be granted a fee waiver if one of the following circumstances applies. One, they cannot afford the fee. Two, they are destitute. Three, they are at risk of imminent destitution. And four, their income is not sufficient to meet a child's particular and essential additional needs. Following from the case of Gineku Legason, the Home Office has become a lot more lenient when assessing fee waiver applications by individuals who are putting in that and also following the law. This is quoted from Gineku Legason and ORS versus Secretary of State for the Home Department, a 2020 case, UK UT 222 in brackets IAC. Now, for that, let me ask Lawyer Charles Asma, first of all, to tell us what the difficulties with fee waiver applications have been, and this update is a kind of good news for everybody.
Right. It is good news.
Yeah.
But I think it's something that a lot of people have already been taking advantage of.
Okay.
So it is just to re-echo the opportunity available to people who may not ordinarily be able to pay the immigration health surcharge and the visa fee associated with applications. But the question is, what sort of application provides the opportunity for a fee waiver?
Okay. Let me just ask you to delve into it just a little bit. What sort of application? The criteria that was listed on there, does it go around or describe a particular application that needs to be put on?
So the criteria tells us what you need to show in order for you to qualify or be accepted for a fee waiver.
Mm-hmm.
The question is it every application that will require or that will attract a fee waiver?
Mm-hmm.
So we have the context. The context is this, that there is Section 3 of Human Rights Act, 1998. And you know, human rights, European Convention on Human Rights transposed into UK law, HRA 1998. Look at Section 3, which says that any conduct, any action, including pronouncement, and here we are looking at the laws and the rules and what have you, regulations, by a public agent, in other words, by any country, that's supposed to enforce and ensure that the human rights work. If you do anything that contradicts such human rights, such action is a breach of human rights.
Okay.
That's point one. What is the action? So there is a rule, immigration rules, which says that if you are making an immigration application, you must pay a fee. That's a rule.
Okay.
That's an action, pronouncement, a conduct by a public agent, as the Secretary of State, Home Office. Is this going to affect somebody's human rights? And that's where we have to juxtapose human rights and the fee for immigration applications. So if I'm making an immigration application and such application is going to affect my human rights, or any behavior of the Home Office is going to prevent me from making that application, we want to check whether such behavior will affect your human right. So what sort of application?
Application. Okay.
Family life application, private life application. These are human right applications.
So if you say family life application, then it means that I'm talking about making an application for my children and my immediate family.
So within the family, we have parents, we have children, we have spouses. So if you're making a spousal application, that's human right application, because you have right to family life, Article 8. If you are making a child application for your child, then the child has right to family life, to be with a parent. If you are making an application as a parent to be with your child, then that's also human right, because right to family life with your children.
Okay.
So that's one aspect. Family life application, appendix FM, family migration. We're also looking at another human rights application to do with private life. So if you look at Article 8, it says we have right to family and private life. So it might not be family life because you are not relying on any of your family members. You are relying on yourself. Based on your long stay in the UK, which the law says must be 20 years under paragraph PL 5.1A of appendix private life. You must be 20 years. If you are not 20 years, you must show that you have insurmountable obstacle to prevent you from going to wherever country that you may be sent to. And that's 5B. So if you are making a private life application, you are making family life application, that is human rights. Therefore, if the Home Office says that you must pay a fee to be able to put in the application, what are they trying to tell you? They've introduced a condition. So that without meeting the condition, you cannot apply.
All right.
And if you don't apply, you cannot exercise your human right. Is human right conditional? No. Therefore, any behavior under Section 4 of HRA says that any behavior of the Secretary of State or any government agency that suggests that it will be difficult for anybody to exercise their human right, that would be inimical to the provision of that act. And therefore, so why fee waiver? The government has to review its own position to say that that's fine. Yes, you have human right. We cannot do anything to affect it. Therefore, but at the same time, we cannot make it open that everybody who is making a human rights application should have it for free. So what do? If you think you cannot pay, tell us and we'll let you have it for free.
Well, so then if I say I can't pay, then it means that I have satisfied those 4 or so criteria that determines my situation, whether imminently I'll be destitute, I am destitute already, it will be against the child's basic rights and private life or whatever. Those conditions, I would have to prove to the Home Office that I have met them. Therefore, they should grant me a fee waiver.
So to speak. So the point now is, come and tell us that you need to have it for free. The question is, what makes you think that you must have it for free? Because it's not an open bracket for everybody that come and have it, if it's a family life or private life application. So you must prove it. So what is the criteria to prove that you meet it or you must be given? And those are the conditions we have shared. So if we put the conditions up again, we'll go through.
Yeah, can we have the conditions up again and go through the checklist to see which one says that? Yeah, all immigration applicants will be granted fee waiver. So the first one is they cannot afford the fee. The second one says that they are destitute. 3, they are at the risk of being destitute. That's what the English says. They are at risk of imminent destitution. And 4, their income is not sufficient to meet a child's particular and essential additional needs. These are the 4.
These are the 4. But so it says, do we have or and in there?
It says
one.
if one.
So it's all. I or II or up to IV, one of them. It doesn't have to be all
All of
four,
them. Okay.
one of them. So either or. Therefore, one, are you a destitute? What is destitute? Somebody who is not able to afford essential living needs is destitute.
Okay.
That means you are technically a beggar, because without begging, you cannot survive.
Okay.
Who are you begging? Could be family and friends, because you cannot provide it for yourself. So do you need people to be able to provide you accommodation? You need people for clothing and all that. Then you are destitute. But it might be that you are currently not destitute, but you are likely to be destitute. That's called imminent destitution.
Right.
So in the next 12 months, will your finances change to the point that you become destitute? So are you destitute, or you are going to be imminently destitute? That's the point. The second point is they are at risk. So that's the imminent destitution. The third point says that, of course, the first one, they cannot afford the fee. So if you cannot afford, it doesn't mean you are not. So it might not be destitute, but you simply cannot afford. You might not going to be destitute. That's imminent destitution, but it simply cannot afford. And the fourth one is that the income is not sufficient
to meet the child's particular.
So I and IV, this is the difference. There's no child.
Okay.
It could be me. I'm making a private life application or partner application or spousal application. But let's get it right here. Spousal application, we have 5-year route and a 10-year route. Don't get it mixed up that lawyer said that if it's a spousal application, you get a fee waiver. There's one that says that if you meet, you'll be put on the short route, which is 5-year route. So if you are going for shortcut, you must meet the condition. That does not attract fee waiver. If you are going for the long journey, 10-year route, then fee waiver will apply. So that's the difference for spousal. But so if you look at 4, it says a child need may not be met if you are to pay. That is for those who have children. Then I, for those who don't have children at all.
Right.
Because not everybody may have a child. So if I don't have a child, does it mean I cannot? You can, if you prove that you cannot afford. But how do you prove that you cannot afford? That is, you have your own accommodation. You can afford your own clothing and everything. You don't need anybody. But if we put your income and expenditure together, the surplus is 0 or negative, or maybe £1 or £100.
Which can't meet the home office fee.
What it means is that if it is £100, now the fee is going to be, currently it's 2,608. If your surplus is £100, it will take you 26 months
to be able to afford.
That means they are going to really punish you for exercising your human rights. That's saved for 26 months. If what you are left with after paying all your bills from your income is £100. So the question is, how much is left to be able to meet the bill of the IHS and the visa fee is very important. So how do I prove it? My bank statement and my outgoings or the bills I pay. So my bank statement must be submitted, to prove that I meet what they are talking about, that I cannot afford.
Okay.
So if my bank statement shows that I have money, even though the money might not be mine, but once it's in there, it's your money, and you cannot explain, then it means you have money somewhere, including your savings.
Right. So if you have just joined us, we're looking at the nugget that was put out earlier in the week. All immigration applicants will be granted a fee waiver if one of the following circumstances apply. And lawyers explained that you cannot afford a fee, you are destitute, they are at the risk of imminent destitution, their income is not sufficient to meet a child's particular and essential additional needs. And that was from a case, Chineku Legason and ORS versus Secretary of State of the Home Department, a 2020 case. Now, moving to another bit that is some hooray for people, especially those who have put in applications for certificate of sponsorship. There was an update that the Home Office brought in this week, and I want to bring that to your attention. All sponsor licenses expiring after the 6th of April 2024 will automatically be renewed for 10 years. The Home Office has added a message to the Sponsor Management System SMS that from 6th April 2024, the Home Office is removing the requirement for sponsors to renew their sponsors' licenses. All licenses due to expire after 6th of April 2024 have now been automatically extended by 10 years. Now, if you need any information on that, if you need that, you'll be taking through what it is, and especially handling the sponsor management system, please contact BWF Solicitors on 0208 493 7340 or 077 127 61884. Uncle Charles, what's happening here?
Right, I think it's good news for those who deserve it.
Okay.
So you can see that I have been careful with the way I am expressing this good news. So that,
those who deserve it. Okay.
Now, Home Office already has a list of people or companies that deserve this amnesty. I call it amnesty because you don't have to ask for it. It will be given to you from 6th of April 2024 if you are supposed to renew your license. That means if you don't qualify to renew your license, will it be given?
No.
No. Who will not qualify? Somebody who is already suspended. Somebody who is already revoked. Somebody who is under investigation. That is why you are suspended. So if your house is not in order, this is not for you because you don't deserve it. So I will qualify it and say that care companies that need license from the Home Office to be able to operate, including sponsoring workers from abroad and from within the UK, must renew their sponsorship license every time it expires or it's about to expire. Home Office is saying that if yours is going to expire from 6th of April 2024, you do not have to attempt to renew it. The system itself will trigger an alert and yours will be renewed automatically for 10 years. So you have 10 years break before anything else happens. For those who the Home Office believes that they have complied with the rules and regulations and so on and so forth. So that's the qualification. People have also been calling to ask, oh, is it for those who are on sponsorship? This is not for workers. This is only for employers. So if you are a sponsored migrant, this is not for you. It is for your employer who had the license to be able to get a COS to be able to sponsor your employment. So only employers.
Well then, good news for employers who have put in the systems and you are working very well. If you need an MOT for your imminent Home Office check and inspection, please contact BWF Solicitors and they will help you do that. And once this information came, they have put it out for you to know that from the 6th of April 2024, all licenses due to expire have now been automatically extended by 10 years. Do your things right and enjoy that facility. And it brings us to the point where we want to say thank you to BWF Solicitors once again for giving us the opportunity to come your way every Saturday afternoon on the program, The Community and the Law. We will be taking a break, and when we come back, we're going into, in fact, something that dovetails into the fee waiver thing. There's another bit that says that you have no recourse to public funds on your status. How do you remove that? Why do you want it removed? No recourse to public funds. I know Lawyer Charles Asma will take his time and take us through what it is. Then after that, he will tell us who can get that condition removed from their status. It's a Community and the Law, and is brought to you by BWF Solicitors. We'll be right back.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate. Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Welcome back and thank you for joining us on the program, The Community and the Law. We're moving and going into our main discussion in a moment, but I want to tell you that if it is that you want to have anything to do with BWF solicitors, don't hesitate. You can call them Monday to Friday between 9:30 in the morning and 6 p.m. in the evening on 0208 493 7340 or 077 127 61884. I have with me Lawyer Charles Asma from BWF Solicitors, and he is going to help us discuss the issues that I talked about when we talk about no recourse to public funds. Now, if you want to call Lawyer Charles Asma, please call him on 07947 63 60 37. 07947 63 60 37. How to get a no recourse to public fund condition successfully removed. Well, no recourse to public funds. Lawyer Charles Asma, help us. What is that?
Thank you very much. Viewers and listeners, a very good afternoon to you. Today we are looking at those who have no recourse to public fund conditions attached to their visas or leave to remain in the UK. And for some reason they need help from the state. How can they ask the state that imposed that condition to remove the condition for them so they can be free to do something? Question is, what would they do with that? We'll come to that. Context. So we are looking at Section 3 of the Immigration Act 1971. And that section gives the Secretary of State power to impose conditions on leave, on people's leave, either leave to remain or leave to enter. So there's power within the Immigration Act 1971 for the government to impose conditions. And what is the condition? The condition will be that under Section 115 of the Immigration and Asylum Act 1999, it says that in imposing conditions, the Secretary of State using the powers under Section 3 of the 1971 Act, can impose a condition that people who have immigration control cannot access public fund. So you can see that there's statute underpinning. And the statute has been then put into the framework for caseworkers. We call it immigration rules. Immigration rules are rules, statutes are statutes, and statutes always have higher power than immigration rules. So immigration, if you look at immigration rules paragraph 6, it will tell you that when issuing leave to remain or leave to enter to applicants, the condition to impose will be that they will not have access to public fund. That means they have to show that they will be able to fend for themselves so that they will not be a burden to the state. Question is, what is public fund?
Okay.
Public fund is the government money, taxpayers' money. When people who work in the UK contribute, it goes into a pot. That pot is managed by the Chancellor of Exchequer, the Minister of Finance, so that they use the money to support the development of the country and to also support those who cannot afford essential living needs for welfare support. Therefore, only those who qualify can go near that money, and that is called public fund. Some of the things that we can get from them are called benefits, public benefits. So the benefits we have, benefits in terms of child benefit, in terms of universal credit, and so on and so forth.
Okay.
So the point we are making is, if somebody is contributing to into that pot and still has a condition and cannot go near that, that becomes a little unfair.
That was the exact point I was coming to. That I in the country, you deduct my national insurance. I pay my tax on my income. I pay council tax. Well, utilities I'm using, so I pay for them, but there's a tax element on that definitely I contribute to. Then you tell me that because of my status, I can't access that pot that I've contributed to. Is it not a human right issue?
Right. We have to separate tax obligation from benefit from the public fund or access to public fund. Tax obligation is for everybody. It doesn't matter whether you are a foreigner or you are a national.
Okay.
Everybody who works in a particular country or community must pay tax. So tax is by everybody. But it doesn't mean that the money that we are getting from your tax is for everybody, including you. That's the difference. Tax is for everybody, but access to the tax money is not for everybody. So access to the tax money is for those who qualify. When you are making your application, they asked you, do you meet the conditions, especially those who are going under the 5-year rule? They will hurriedly say, I work, I make enough, and da-da-da, and da-da-da, and da-da-da. And even when they are writing a letter to support the application, they will say, I am okay, and therefore I will not be a burden if you admit me, or I will not be a burden if you grant me opportunity. Now you've been granted, and you are saying that you can't, and so I want to become a burden. That's contradictory. Irony of your own statement. So that's that point. But there's flexibility within that if you haven't said yes, and now realizing that it is not the case, it can come back for us to reconsider. That's the point for discussion. Okay.
So then I realized that I'm in trouble. I said I could, now I can't. How do I prove? Because with lawyers, evidence is the name of the game. With Home Office, yes, evidence is also the name of the game to say that I can't afford. How do I prove that I can't afford?
Thank you. So remember we used words: destitute, destitution, imminent destitution, and children's needs.
That's right.
When it comes to that bit, everybody can apply to get it to be removed.
Mm-hmm.
The point I want to put across before we even move on with the conversation is that the moment you go for a fee waiver and you are applying for your main application, you tell them that these are the reasons why I qualified for a fee waiver. So when you are granting me, bear that in mind.
Okay.
They will bear in mind and remove the condition automatically. They will
Okay.
not impose any
no
condition
recourse,
because you are already a beggar by going for a fee waiver, so to speak.
Mm-hmm.
And because of that, if they are going to impose condition for you to go back begging, then that doesn't make sense. So most people who have fee waiver access, other things being equal, will be granted leave without condition. And those of you who have been granted fee waiver, if you like, check. I'm sure because of your fee waiver, you didn't have any condition attached. Some also do have condition attached because they don't ask for that consideration from the outset. So that is the point.
Very interesting observation here. I have asked for a fee waiver. It has been granted. When I'm making the main application, I didn't say that I asked for fee waiver. So consider that when you're making your final decision. If I don't ask, it means I won't get. Or it has to follow from that because they granted me from the beginning. So I didn't need to have to say that to them again.
Well, that is the baseline, but the baseline doesn't always apply to all circumstances or in all circumstances. It may apply, but others that will not apply. So let's look at the context.
Okay.
When you are making your fee waiver application, you are establishing the point that you cannot pay for the application fee. Full stop. That's what you said.
Mm-hmm.
You didn't say that you cannot live after your application.
Okay.
You said you can't pay for the fee, so they should remove the fee for you.
Mm-hmm.
So you've been given a waiver. Now you are applying. There are questions there. They will ask you, are you working? You may say yes or no. They will ask you, are you going to be destitute or are you going to struggle to meet your living needs? You may say yes or no, and so on and so forth. So the questions and the answers you provide will trigger what should be done when they are granting you, whether to impose condition or not to impose condition, having been already considered for a fee waiver and meeting the destitute point. Remember, one of the criteria is that you cannot afford the fee.
Mm-hmm.
Up to what point? Up to the point of the application. And therefore, after the application, it's likely you can afford your living needs.
Okay.
And mind you, you were actually affording your living needs because you said that your income is equal to your outgoing. Just that because it is zero balance or surplus left.
You don't have money for extra things.
For the application.
For the application, which is an extra anyway.
Okay. Well, if you say extra, somebody will say, by extra will be my food, my this, my that.
Right.
You can't have money for your application. So, but I'm okay, I can live. Just that I can't afford the application fee.
Mm-hmm.
How do you live? Yourself. Because you work, you provide for yourself, but you can't afford the fee because you don't have surplus and so you don't have savings. So they've granted you amnesty from the fee, which is the waiver. You've made your application. So that's fee waiver. But it doesn't follow on always from there that having been granted a fee waiver, you also have no condition imposed if you don't make it clearer. Mm-hmm. So in your application, what you say is that already they know your story. They know that you can't afford a fee, or they know that you're going to be destitute, or they know that, or you are a destitute, or they know that you're going to be imminently destitute, or they know that there are children involved. Especially when there are children involved and you've been granted a fee waiver, you have to make it clear in your application that I will need help subsequently, based on the responses to the questions and the representations you make as part of your application. So if you look at the application, there's always additional information. It is not there for the fun of it. There must be a reason. And therefore, if you need to use it to make a point. Now, when we are submitting applications, we actually add letters and all that. Those letters are not compulsory. What is compulsory is the application form. Therefore, if you want to add anything, we signpost that please see the letter I have added. Because the person doesn't have any obligation to see your letter unless you have directed them. But where you don't even add the letter, you can use the box, additional information box. I have applied for a fee waiver because I am currently destitute, or I am currently not destitute but cannot pay for the fee. However, I'm going to be imminently destitute because in the next 12 months, my job is already at risk and I may not be able to meet my essential living needs. This means I will be relying on friends and family for support, which may not be reliable or permanent. This is going to put pressure, blah, 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 blah. And therefore, in considering my application, consider me for XYZ. If you say this, would that cause them to think about whether to give without condition or to give with yes? But if you don't say anything, and you have only been granted the fee waiver because you couldn't pay the fee, would they also grant the leave and say that go for benefit? No, automatic.
Okay. Then the other question is the no recourse to public funds, that application, do you necessarily have to have had a fee waiver before you do that?
No. So the fee waiver bit I chipped in is for those who had their leave, the card, and on it there was no recourse to recourse to public fund. If the no recourse to public fund is not there, it means they have recourse to public fund. They haven't asked for it, but the way they put in the application has made it possible that there was no condition. So they can go for. Therefore, if you have the condition there, then you must take active steps for it to be removed.
Okay. Take active steps for it to be removed, and we're going to go through how to do that. First off, if you were me, if I were you, I would straight away go to the lawyers for them to do that for me. But listen, the program seeks to empower you, one, to understand what it is that you are doing, and two, to be able to stand on your own 2 feet, to be able to do things yourself. How are we going to do that? Laura, the steps. How do we do this?
Right.
Should I tell people follow Kweku's advice? Go and say it. Or you tell us what is that?
Right. I mean, the essence of this platform is to empower people, so that those who can will rely on themselves, and those who may not necessarily be sure will still come to those who can make it certain for them. There is case law underpinning to this discussion. During COVID, so 2019, 2020, thereabout, it became very, very difficult for people to survive. People who have no recourse to public fund struggled to meet the needs of their children. What it means is that if you have children and you have no recourse to public fund, you will not necessarily be thinking about yourself, but the children's welfare becomes an issue. There's also a duty on the state, especially the borough within which the child lives, to ensure that the child needs are met somehow, where without meeting such need, the child is exposed to harm. Or if the child is hungry, that's exposure to harm and all that. So councils or the boroughs have duty to ensure that children within their catchment areas are supported. That's why when a child is in need and the parent has no recourse, the council will step in not to help the parent, but to help the child alone. But this time, you want to have the no recourse removed so that you can help yourself and your child. So as I'm saying, during the COVID era, children were in serious trouble, exposure to harm, because parents couldn't afford. Jobs were lost. A lot of them were put on 0-hour contract and so on and so forth. And so there was chaos. So there was a group that people came together and supported some children to take the government on this. So they took the matter to court and challenged the government that, yes, you have the power under Section 3. You have the rules backing you, Section 116. And the immigration rules say this under paragraph 6. However, you cannot leave us alone because of my mom's position. We cannot, my mom doesn't work because she's lost the job. There's no savings. There's no money. We are even getting evicted from where we live. And yet we cannot access public funds. So what do we do? So the matter went to court. And the judge considered the plight of the children and said that, right, children who are in such positions should be given opportunities so that their parents, no recourse to public fund, should be removed so that parents can access public fund to help such children. And that is the context.
Okay.
So how do you do it? Because you must prove.
You must prove, yeah.
That you can't afford. So how do you do it? Just like fee waiver, you have to provide your bank statement.
Okay.
So in your bank statement, it's always 6 months up to the date of the application. So if the application is today, 27th of January 2024, you need bank statement going back 6 months. Then it will be assessed for where the money came from and where the money went to. The outgoing, the inflows and outflows in the bank statement. You have to explain each of them. Then they will make a decision that we agree with you, and therefore on that basis you have to have the no recourse removed.
They would have to agree with you that giving income X and outgoing Y, you can't afford it. Is there an issue of discretion, or the fact that you provided the detail with supporting documents, it's enough?
So it's objective assessment. Okay. So there's no subjectivity. So the assessment is on the evidence you have provided. Bills and bank statements, okay, which shows your income, and outgoings, which might not necessarily reflect your bills. So let's take classic example of somebody who applied for the conditions to be removed and was denied. The person presented bank statements, about 3 of them. So what does that mean? Provide all your bank statements in the UK. If you miss one or leave one out, they will find out. How will they find out? They use the credit reference system, Equifax, Experian, Check My File, and all those platforms, and they will know. So it's not a case of hiding it. They will find you out. So please provide all the statements. And in each statement, you have money coming in. So this individual I'm talking about provided a statement. Monies were coming in, but he said the monies were not for him. Ordinarily, your bank account is for your money. Ordinarily. Therefore, if somebody puts money in your bank account, presumption is that it's for your money. So you can't say that this money is not for me, and therefore don't add
it. you may have to prove it then.
But how do you prove that somebody is using your account?
No.
Right. So you may be doing 3, 4, 5 jobs, but you can't say that you are not the one doing all those jobs. Because in your bank account, there's money from source A, source B, source C, showing that you are a very hardworking person, doing a lot of.
So if you hard work.
So if you say that A is mine, B is mine, but C and D are not mine,
what are they doing in your account?
What are they doing in your account? So you can't say they are not yours, because the evidence is on the paper you present.
Okay. So if I get myself in a situation where, for some reason, somebody sends me £1,000 to buy a few things here for them. And I've spent the money. So it shows in my outgoing. It came in, it showed in my outgoing. Can I provide evidence to say that this money came from X and I bought Y for them and it's gone? And it's a one off.
Yes, they will ask you, and you have to, of course, even before you put in that, you send your evidence, you have to, because you have to annotate every transaction that is 250 plus. I say that I will annotate from £100 so that they won't come back and say, what was that?
What about the £100?
So I do it from £100. But the point is this: there was one instance where that was just after COVID. So the person, and this conversation is similar to fee waiver anyway. So the person was making a fee waiver application, and they said, "Oh, but you have this money in there, and this money went to this person. It came from here, it went there." What's the explanation? So the person explained that before COVID, or just around that time, I gave my friend money to buy me a car because it's cheaper where they live. Now, COVID set in, and it wasn't possible to get a car for the purpose I had. So I told them to give it back to me.
Okay.
So they refunded the money. So the money came in. I gave first, it came in. The same person. That is the reason. Or you gave money, it came back. This time, could be also that you are very, very kind person, and kindness is a virtue. So people come to you for assistance. But even though you are kind, it is still not for free. So they will give it back to you. So you gave the money. You are not a lender, but you are a kind person. Benevolence. So my friend was in serious trouble, or how to pay deposit, how to do this, how to do that. There was no help, came to me for assistance with a promise of giving back. I gave it to him, he gave it to me back. Or I gave it to him and he gave me part of it at this time and the rest at those times. That's why you see his name or her name everywhere.
Okay.
Got to explain. So these are different ways that people have clarified the transactions in the bank statement. But it is your duty to clarify them.
Okay. So I have my bank statement. I have indication that there are outgoings, direct debits, there are some standing orders, and all those things. For instance, if I have a direct debit for my broadband, my mobile phone, I have a direct debit for my electricity, which is utility, I have a direct debit for my council tax, I have a direct debit for my water bill, I have a standing order for my children's upkeep, either in school or for clubs and all the other bits. Banks do not lie. When I've provided my statement and it shows that I've annotated all that, do I have to provide further evidence to the ones that appear on the statement?
I mean, it's obvious, as you said. It's a prima facie evidence that this money went to EE. What for? Broadband, mobile phone contracts, da 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 da. It went to Thames Water, water bill. It went to Mr. Patel, rent. It went to BWF solicitors, legal fees. It went to charity. Oh, you don't have money, but you can do charity.
Oh, philanthropy is a virtue. You mentioned it.
Yeah, but if you are philanthropic, then why do you come begging? That's by the way. So, I mean, if you have a lot of that, then unless of course it's clear, for example, cancer research, one off, okay, but not to John Mensah, Araba Bento, and Amma Bedua, and they are all charities. That may
So
not be,
you apply common sense to it, basically.
that may not be proving charities.
Okay.
Unless you have evidence that these are charities.
Right. But if you're contributing to so many charities, then you're not destitute.
Well, I don't know whether a beggar cannot be doing good. but then, I mean, you can see that there's a lot of common sense assessment here.
Okay.
I mean, and if you are genuinely begging, you cannot have the appetite for goodness.
Obviously.
Yeah, that's why rich people always get, because they're able to do good.
Well,
And those of who are not necessarily lucky, are not, because it's attraction, isn't it? Exactly. But that is by the way. So the point is that when you are explaining those things in the bank statement, you just have to make sure that you are very, very clear.
Okay. Well, if you just joined us, we're having a discussion on how to get a no recourse to public fund condition taking away from your situation. And Lawyer Charles Asma is taking us through the steps and the criteria you'd have to satisfy. If you have a question, you can text now to our phone number in the studio 07399 208468. And you can also send a WhatsApp message 07950422780. The studio number will be active in a moment, and the number is on your screen at the bottom of your screen 0208-493-7345. 0208-493-7345. We will be going back to Charles Asma to pick up the discussion. Let me just mention to you that we're having a few issues getting our feed on Facebook. But it's being investigated. So if you're having difficulty finding it there, the Facebook feed is not on at the moment, but we're live on YouTube and all the other social media platforms. So when you pick up the link, share and like the page as well, so that and click on the notification button, I should say, so that when we put out any content, you will be notified and you get there. 0208-493-7345. Send a text 07399 208468 and WhatsApp with your voice notes 07950-422-780. It's the community and the law.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate. Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
No. Okay, welcome back. Thank you very much for still staying along and staying around and going along with us. How to get a no recourse to public fund condition successfully removed. Your texts, your WhatsApp messages, your phone calls are invited now. Lawyer Charles Asma is here with us and he's going to help us unravel that. 0208 493 7345. Text 07399 208468 and a WhatsApp message 07950 422 780 07950 422 780. Lawrence Osasma from BWF Solicitors is right here with us and he's ready to take your questions and concerns. It could be about any other issue of law you could ask, but if you still want any clarification on how to successfully remove the no recourse to public funds, you can also call in now. Lawyer Tosaswa, this one is asking whether for DV purposes or DV reasons, one partner is moved from that situation and sent to another situation. When the person went to the new situation where the children and the parents are safe, they realized that the parent has been removed from the DV situation had no recourse to public fund on their status. Would that be a condition qualifying that parent to have that removed?
Well, when you are in a DV situation, by the way, DV means domestic violence.
Okay.
So when you are in a DV situation and you have limited leave to remain, your wish is for you to be considered for settlement. That's indefinite leave to remain, provided you can prove that there was DV situation.
Mm-hmm.
So the fact that this person has been removed from that DV situation means that they've reported and action is being taken.
Okay.
In the meantime, remember this mother or father and the children depended on the sponsoring parent or the sponsoring partner, the one who brought them here or the one who is sponsoring them in terms of the applications.
Mm-hmm.
So it's usually okay. It's possible that it will be a man. It's possible that it will be a man who is perpetuating that violence,
mm-hmm.
and the victim is the woman.
Yeah.
But it's also the case that it can be the man who is the victim of that violence.
Mm-hmm.
So it's either way. So can be a man suffering, can also be a woman in that DV situation. So if you're a man and you are in a DV situation, you can do the same thing as women will do. The law is for both gender. Now, so what we are saying here is this. This person who has been put in that situation is going to make an application.
Mm-hmm.
Already they are in that imminent destitution.
Mm-hmm.
So they will be granted temporary leave. It's usually 6 months.
Mm-hmm.
And within that time, they will be given that temporary leave will grant them access to will grant them recourse to public fund.
Okay.
So they can access support to be able to survive for that 6 months whilst they are putting in the main application. So while they are putting in the main application, they will put in a fee waiver so that they can have the application for free. And once it comes, they put in the main application. Is it also possible that somebody in a DV situation may not qualify for fee waiver? Yes. There are about 3 of them that had their DV successful, but they didn't meet the fee waiver criteria. So they paid for it, but it was successful. It was successful because they were able to prove the DV situation.
Okay.
Right.
Okay. Well, this other question says that Okay, I think it's about a dependent in a certificate of sponsorship situation. Lawyer, I understand that from spring, people who are on the care worker route cannot bring in their dependents. But what if I am in the country and I divorce my dependent? Can I marry again? And if I do, my new spouse, would that ban affect my new spouse?
So the rules say that if you're already in the UK on this um, program,
Mhm.
the change will not affect your dependents.
Okay.
So if you're already here as a skilled worker migrant and on the 6145, which is general carers, care support, and what have you, care workers, and 6146, which is the senior carers, if you're on that, you're already here. So your dependents are okay. They can come at any time. Answer to this specific question. I'm already here. I had my dependent. I came with maybe we've divorced. I have remarried. Can I bring the new wife or husband? Or this they will be affected? It is not the person coming that must be here. It is the sponsoring partner that must be here already or must have already obtained the visa. So if you're already on the program, you are going to bring your partner, whether partner can only be one at any point in time.
Anyway, yeah.
So this is your partner you are bringing,
Mhm.
and the law will be lenient. I don't think that they will say, "Oh, you had one chance, so you can't have second chance." No. So I would say that there should be no
And
complication.
I'll ask a follow-up question on this one. So if I declare that the partner that I brought in before the ban is in the country and we have divorced, would I have to declare that that partner that is not my partner anymore, that is not my dependent anymore, be removed so the place can be taken over by my new partner?
It's automatic. The moment you sever relationship with a person, any rights attached, any right derived from that relationship is gone. So after divorce, this person, that dependent, cannot say that their visa is valid.
Okay.
I mean, that's it's not even about legality. But once we stretch the common sense to the rules, then legally this person cannot have the rights before. So this is not like where you have retained rights.
Okay.
You
It's curtailed when your relationship is
you have retained rights. So you have to prove that the relationship is severed by death or divorce, and you have to prove that before this point you had a right.
Okay.
So this skilled worker dependent will say, I had a right. But there's no law which says that skilled workers dependent who have severed relationship can retain their rights.
Okay.
So once the right is gone, it's gone. Can somebody take over the right? Presumably, yes. And that's the whole answer.
Okay. Um, this next one is very interesting. It's about fee waiver, and the person is saying that um, I can afford only half of the fees. Can I tell the Home Office that I can afford only half, so they should waive off half of it?
It is possible. So when you're applying for a fee, I don't see why you have to go for half. However, if you have part means, if your means can meet part of the fee, they will give you the rest. So the fee waiver can be granted partly or fully.
Okay. Well, you can just text in now 0208. Oh, no, that's for the phone call 0208-493-7345. Your text and your WhatsApp message is 07399-208468, and WhatsApp 07950422-780. The lines are active and waiting for your calls. We're live on BWTV, and it's the community and the law. This afternoon, we have lawyer Charles Asma from BWF Solicitors supporting us. I will be going to the quiz segment in a few moments, but let me remind you of our nuggets that we talked about, and it dovetailed into our discussion for today. Well, first of all, let me do the community update again. And it says all sponsor license expiring after the 6th of April will automatically be renewed for 10 years. This is an addition that the Home Office has made to the sponsor management system. And it says that from April 6, 2024, the Home Office is removing the requirement for sponsors to renew their sponsor licenses. All licenses due to expire after 6th of April have now been automatically extended by 10 years. One details, BWF Solicitors 0208 493 7340. Now, a nugget. Asking government to pay your application fees. Can you do that? Now, this case, our Gina Kulixon and OR as Vice Secretary of State for the Home Department says that all immigration applicants will be granted the fee waiver if one of the following circumstances applies. 1, they cannot afford the fee. 2, they are destitute. 3, they are at risk of imminent destitution. 4, their income is not sufficient to meet a child's particular and essential additional needs. Now, following from this case, the Home Office has become a lot more lenient when assessing fee waiver applications by following the law. And look at the 4 conditions. Do you satisfy any of them, or do you meet any of them, so to speak? And the law says if one of the following applies. 1, you cannot afford a fee, you are destitute, imminently you'll become destitute, or your income is not sufficient to meet a child's particular and essential additional needs. We will be bringing you a case scenario on this one, and I'll ask to find out if you really understood it and you can get it correct. Keep sharing the page. You remember last year when we had Tilly Duma sharing the page, the largest and the highest number, she was rewarded. It could be you this year in the year 2024. So share the page, BWF Solicitors, BWTV, both on Facebook and YouTube and all the other social media platforms. Now let's say thank you to BWF Solicitors and we'll be right back.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Welcome back, and thank you for sticking with us. 0208-493-7340. If you want to speak to BWF Solicitors in Ghana, the number is at the bottom of your screen: 0233 5558 95959 00233 5558 95959. For emergency situations, call BWF Solicitors or text them on 004477 12761 884 004477 12761 884. Now, Lawyer Charles Asma is my guest this afternoon. And as I mentioned, if you would want to speak to him directly, you have the chance of doing that. Let me give you his number again. And we have a very nice number. I don't know how he got it. Last his number is 07947 63 60 37. 07947 63 60 37. Now he's right here with me, and um, let me ask this. Last month, I have had a certificate of sponsorship. I have a 3-year contract. I've come in, and I'm just paraphrasing somebody's question. I've come in, and my employer says that, well, unfortunately, they have lost part of their contract. So the number of hours that I'm supposed to have on my schedule work has reduced. The law says that I can do 20 hours outside of that organization in a similar industry. Can I pursue the main number of hours from where I'm getting the extra 20 hours?
Technically, no.
Okay.
Because the person helping you out, which is the 20 hours, cannot take over the one who brought you here.
But how do I, because obviously I'm getting some hours, even though not up to the number. Can I use that as a basis to say that, well, I've lost a few hours, not due to anybody's fault, but maybe circumstances have changed and all that, and say that I'm going to look for somebody else with certificate of sponsorship that may have some number of hours I could use on my shift?
The rule is that you can work extra 20 hours. They made it unlimited, and it's now back to 20 hours. So if you work more than 20 hours, then you are breaking the rule. Once it's found out, they can say you've breached or broken the rule.
What does this person do in this situation? He can get 20 hours, just 20 hours. His main contract is in jeopardy, or probably the number of hours is reduced. What can this person do?
Well, what can the person do? It's like getting a job wherever in the world, not necessarily coming to the UK to work. You are in your home country, you found a job from company A, or you got an offer with company A. Soon as you started, company A has folded up. What do? Similar situation. Or soon as you started, company A is not producing as much as possible, and they're not giving you enough. Company A can say that, right, it's not your fault, so we'll still pay you until we found a job for you. Or they can choose not to do anything and tell you go to hell, in a way. That is where it becomes, what do I do?
Okay.
Because you depend on them,
right,
for your leave. So it's a matter of conversation with them. If they are willing to understand you and work with you in terms of assisting you, maybe, okay, we'll top up the money or da. But how many of them are kind enough to do that?
Can the original organization negotiate with another organization that has a similar certificate of sponsorship to say that my employees are suffering, I've run short? Can I kind of piggyback you and get them to do some extra work? Does the law allow that?
Well, I mean, if I'm a worker and you tell me that, you know what, this is the setting, that's where you was meant to be working most of the time, but we have the other setting somewhere that because you don't have enough work here, I'm going to take you there to be able to do blah 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 until this place picks up. Mind you, you are not changing the payroll system.
Okay.
It's the same company. Where they work doesn't matter. It's who pays the wages and also gives them the pay slip and also goes through the compliance with HMRC. That matters. So if you are sending me there and I end up getting pay slips and stuff, money from them, I'm going to be put on payroll to suggest that I have another employer. then I now have 1, 2 employers. Question is, who is the main employer? But if you send me there, and all I know is that I'm going there to work and still working for you, that is not in any way going to break any rule.
Okay. 0739920846 for text messages, and I'm picking most of them here. If someone applies for a student visa to travel from Ghana to the UK, and for some reason the visa is delayed and eventually not granted, school had also reopened, so the school declines the offer. With regards to the health surcharge law, is it usually paid by the student plus dependent, and also is it refundable in this scenario?
So, question, what has happened? Has the person been refused a visa? Yes or no?
Delayed, refused, yes.
The person was refused eventually.
Eventually was not granted.
Oh, okay. So if it wasn't granted, then usually the health surcharge is refunded.
Okay.
But the health surcharge is for you to come, so that once you are here, in case of medical emergency, you have somewhere to go. So you are paying for health insurance, literally. So if I'm not coming, will I lose that health insurance?
No.
You shouldn't. So that will be refunded.
Okay. This one says that I applied and had my EUSS granted. At the time of application, I did not include my children. Now, knowing that the deadline is past, can I now add my blood children to my situation so I can bring them in to live with me in the UK?
So this EUSS, is
yes.
it? Okay.
That gate was closed a long time ago, I guess.
No, I said what? Children. So children are still ongoing. I mean, they are your nuclear family members, so that's still fine under EUSS family permit. What a person has said is, okay, when they were making the application, they did not mention that they have children. Is that what they are saying?
Yes.
But how? So the question is, are these your children? If you're able to prove that these are your children, then it doesn't matter whether you forgot to mention them or not. They are my children. Why did you not mention their names? Yes. Well, unfortunately, whoever helped me with the application didn't listen to the instructions I gave. Maybe. But if they are your children, how do you prove this? Of course, you're going to use birth certificate. And that is where it becomes a little contentious. One, it didn't disclose when you had the opportunity. You are now mentioning for the first time that you have children, but you forgot to tell about them. And yet you are using birth certificate issued recently.
Okay.
What's the level of credibility in here? Very low. What about DNA? What's the level of credibility that these are my children?
Almost
very high. That's how you prove your case.
Right. So does it matter the age of the children?
Under EU provisions,
yes,
it doesn't matter, but there is a condition as to how the children will be treated by age. So if the child is under 21, you don't have to prove that you look after them.
Okay.
If the child is over 21 and above, you have to prove that they still depend on you or you still look after them. Because even though they are old, they cannot fend for themselves.
Right.
And you have to show how you do it, how long you've done it, and what are they doing themselves, and what do they use the support you give them for. You have to prove it.
A scenario is just coming to my mind. Let's say, for instance, the person lives in one of these EU countries and didn't do when doing the application, didn't include their children. Their children are over 21 now. They have their own indefinite leave to remain in their country. I was going to use the local word. They have their own assets in that country. If now the parent wants to include them, do they have to prove that I've been looking after these my children. I forgot to add, they are of age. They could be on their own and probably would want to move to the UK themselves rather than depending on me. Could that be possible?
So is that your question? Should I do it or they should do it themselves?
Kind of.
Well, I mean, if they can do it themselves, you save yourself the stress of proving that they still depend on you.
Mhm.
But if they can't do it themselves and you have to bring them, then they have to prove that they still depend on you, or they are 21 and above.
Okay.
Yeah. If they have, provided they have not, they are not living independent life, they have, but even that, they are your children, because under EU, it's still a family relationship that you have to prove. The moment you prove family relationship, whether this or whether that, this is my child. But the only bit is where you have to show that they depend on you. So if somebody is already independent, living an independent life, they are working, they are looking after their own family and so on and so forth, how will you prove that you still feed them? That means they are old enough, yet they are not capable of living an independent life. So they still depend on you. That's the EU conversation.
Okay.
Outside the EU, you can't do it because the child must be under 18.
All right. If you have any question, let us have it 0739920848. That's for text messages. For WhatsApp and audio messages, 07950422-780. Or you can call in to the studio 0208-493-7345. Next, we're going to look at our quiz. And the scenario, I can assure you, is based on the nugget, which says that this is a question. So I will just read it quickly, then we'll go for a break and we'll come and pick up your answers. Anna Grace is making an application to stay in the UK on the basis that she has parental responsibility for 2 British children. She currently has permission valid until March 2024. The fee for application is 1,053. Immigration health surcharge is 2,587.60, which is a total of 3,640.50 pence. She works part-time and earns 16,000 per month, 1,600 per month, but spends 1,450 on essentials and rent and saves 150 pounds. She says she cannot afford the fees. What must she do to qualify for a fee waiver? Let's look at the scenario again. Anna Grace is making an application to stay in the UK on the basis that she has parental responsibility for her 2 British children. Currently, she has permission which expires on the 20th of March 2024. Now let's look at the fee she's going to pay for her application. The application fee in itself is £1,053. Immigration health surcharge, as it is now, is £2,587.60. The total that Anna Grace is going to pay is £3,640.50. Anna Grace works part-time and she's paid £1,600 per month. She spends 1,450 on essentials and rent and saves £150. She says that she cannot afford the fees. Okay, fine. What must she do so that the Home Office will tell her that your application is free of charge? A. Anna Grace should show that she has 2 children who require all her savings. B. Anna Grace should show that she cannot afford the fees by providing her bank statements and a list of expenditures. And 3. Anna Grace should show that her leave will expire very soon. Now start work. I'll be right back.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, The named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate. Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Okay, so let's see how well you worked. Let's go back to our question and what does it say? Anna Grace is making an application to stay in the UK on the basis that she has parental responsibility of 2 children. Currently, she has permission valid until March 2024. The application fee is 1,053. Immigration health surcharge 2,587.60 pence. And the total will be 3,640. She works part-time and earns £1,600 per month, or spends 1,450 on essentials and rent and saves only £150. She says she cannot afford the fees. What must she do to qualify for a fee waiver? 1. Show that she has 2 children who require all her savings. B, she should show that she cannot afford the fees by providing her bank statement and a list of expenditures. And finally, is she to show that her leave will expire very soon. Let's see what answers you have. Do you have any on the board we can show? My thinking is, could it be A? Could it be B? Maybe C. What do you think? Let's get into this quickly before I go to lawyer Chelsea Smart to help us unravel this. I would say that if we could go back to the nugget that tells us something. All immigration applicants will be granted a fee waiver if one of the following circumstances applies. They cannot afford the fee. They are destitute. They are at the risk of imminent destitution. 4, their income is not sufficient to meet a child's particular and essential additional needs. The rule and the update says that you meet one of the following. The 4 that I mentioned: cannot afford the fee, you're destitute, imminently you becoming destitute, your income is not sufficient to meet a child's particular and essential additional needs. Now, following from this case, the Home Office has become a lot more lenient when assessing fee waiver applications by following the law. Now back to the question again. Let's see what we have. Emma Grace is making an application. Well, she works part time. Yes, she earns some money, but after paying rent and essentials, she only has £150, and the fee there is 3,640. Let's even say it's 3,000, or say it's even 4,000. 150 divided by 4,000 would take a long time before she can make that. Even when we say that she's spending all the 150 on the application. So what can she do? One, does she have to show that she has two children who require all her savings? Two, does she have to show that she cannot afford the fees by providing her bank statements and a list of expenditures? Or C, does she have to show that her leave will expire very soon? Well, the leave will be expiring we in January, so February, March, and it's gone. What are your answers? Um, Time and Tide says so is for Norman, so I will go to lawyer Charles Osman again and say, my inclination is that Anna Grace should show that she cannot afford the fees by providing a bank statement and a list of expenditures. Would I be right?
Yes, you'll be right, because as we explained, fee waiver, though available, must be proven that the applicant needs it. So more or less it's means tested, so that the floodgate is not opened. So she has to prove that she cannot afford the fee under the circumstance.
Right. Okay. So as Lara said, the answer to this week's test is B. If a person demonstrates upon proper proof that they cannot pay the fee, the Secretary of State must agree to waive the fee when an applicant is unable to afford the fee and has human rights claims. That's R. Carter versus Secretary of State for the Home Department, England and Wales High Court judgment, and a case number 2603 is an admin case. So that's that bit there. So we're going back, and we're going to ask lawyer to give us a summary of what we've gone through, a quick run through what needs to be satisfied so we can get a no recourse to public fund condition successfully removed from our status. Lawyer.
Hello, viewers and listeners. Once again, so a quick recap. Today we've looked at people who have no recourse to public fund and wishing to have it removed. What ought to be done? They must first apply. Once the application is submitted, or once they are going through the application process, they have to show their income and expenditure. The expenditure should ideally be more than the income, because if the expenditure is equal to the income, then you are not in a serious situation as to warrant somebody's money. So the expenditure must be more than the income. What it means is that without support, you cannot survive on the minimum income that is far less than your outgoing. And the outgoing here should be essential outgoings, not frivolities such as holidays and so on and so forth. They are important, but they are looking at your essential living needs. So your rent, your food, your clothing, your grooming, your entertainment, your fitness, and so on and so forth, your health, your children's needs, school support, school activities, school uniforms, after school clubs, and what have you, all put together. If that is more than your income or your household income, then you are in trouble. So you have to put all this together. Bring your bank statement for 6 months for yourself, for your children, and for your partner, if there are. Put all together and show that every transaction in the bank statement is provable. Once they are all proven, pointing to the fact that your expenditure is more than your income, your application should be successful. This is what we have covered today. If for any reason you need further clarifications, please do not hesitate to knock on our doors. Shalom.
Well, I think just before you go, somebody's text message has come through, and it's a bit critical. If you don't mind, I would
Right,
put
sure.
it across. It says, "Please advise me on how to go to Ghana and bring my child who has been giving visa in terms of flight bookings. Can I book British Airways return from Heathrow to Accra for both of us so that his seat will be vacant? Like the person going from
So where is the child?
the child is in Ghana.
Right.
Okay, so going, then we buy a pair of tickets for the parent and the child who is in Ghana.
So the parent is here, wants to go and bring the child.
Bring the child.
And wants to see whether to buy return or not to
buy return for both of them.
Okay.
But when the parent is going to Ghana, we'll be going alone, but it will be coming with. So then the child will miss the going out flight, but it doesn't really make sense.
Okay, all right. I think let's simplify it for our friend.
Mm-hmm.
Well, she's asking. She wants that if she is to go to Ghana to bring the child, because the child has got the visa now.
Yeah.
How should she do it in order not to waste money on flight?
I guess so.
I suppose.
Yeah. But I guess so. But to me, why I was going on about it, it doesn't really make sense to me. The visa or the permit that's been given you is for the child that is outside of the UK, and you have the right to go and bring the child in.
Exactly.
So why would you waste money buying a ticket and missing one leg of the ticket and coming back? The airline could even give you problems because when you miss one leg of the ticket, they may think that it was a no-show. So
what do you mean?
I'm going to
buy return.
Yes, I'm going to Ghana.
Yeah.
I'm going to bring somebody from Ghana.
Yes.
Then I buy my ticket from here, and I include the person I'm going to bring from Ghana. It doesn't make sense.
Okay, I get what you mean. So buying two instead of buying one, and buying the other one separately. Okay. So if our caller or questioner is listening, all you want is how to go and come without wasting too much money. Okay. So the child is coming to stay, I suppose. It's coming to stay. So the child will get a single ticket, one way.
Yeah.
So you buy separately, the same flight though. So the date will be the same. In terms of seat, you have to choose where, so you can do the seating later. So you buy single, no return for the child. So one way for the child. And of course, yours will be returned.
That's it.
Yeah, that's it.
Anyway, save money.
Yeah. But if we didn't get you, because of that, we didn't give you the right response, please call us so that we can get your facts better and assist you. You can call us later.
Okay. Now you've done your summary, but let me quickly ask. We've got a few minutes to round up. Let me quickly ask. What's the current situation with the certificate of sponsorship, but the specialist occupation list? You know that list. What's the situation now? Are they taking a lot from it, or it's still the same? People think that it's all about just the construction and the care worker route. What's happening?
There are a lot more on there. I mean, thousands of jobs or occupational areas. And of course, some of them do not have immigration health surcharge amnesty. If it is within the ones within the health sector, you don't necessarily pay health surcharge. That's why those ones, you only pay the visa fee and it's always minimal. But the ones that are not in healthcare, you pay plus immigration health surcharge, and that is high most of the cases. So, but there are a lot of them still there. They haven't really changed much. They keep amending, but it's not so different from what we started with.
Okay. So for each of these, does one have to do an English test if you don't have a qualification or a degree that was taught in English?
So English language is English language for those coming to live in the UK, including more than 1 year. So if you are a visitor, you don't. But if you are not, then you did English. So that will apply.
Well, then I would advise that you consult KT Ed Consult for them to help you with the English language. They do their classes every Monday and Wednesday, so you can call them and get them to support you. In addition to that, remember that when you have your certificate of sponsorship, there is the sponsor management system that you need to really maintain. If you need help with that, come to BWF Solicitors and they will help you with the BWF Solicitors is located on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, 766 North London. They work Monday to Friday between 9:30 in the morning and 6 p.m. And if you would want to meet them over the weekend, you have to book an appointment. BWF Solicitor 0208 493 7340 0208 493 7340 or the emergency number 077 127 61884 077 127 61884. And you would be happy to also note that BWF solicitors are community lawyers, the trusted community lawyers, I should say, have put in place several educational programs that will help you, one, empower you, and also get all your questions answered. And you can, beyond that, come over and see them in their offices, as I mentioned earlier on. On Thursdays, we have a session with Rainbow Radio International, and that's between 9 and 10 a.m. in the morning. And then Friday, we have our free legal education. That's between 9:30 and 11 a.m. Now, my team, my co-presenter hosts that, and it's all brought to you by BWF Solicitors. Now, we crown it all with the Community on the Law that happens every Saturday between 4 p.m. and 6 p.m. So make sure you make a date and attend, or come and enjoy any of these programs. It's so enriching, it's so full of knowledge and education that you will be happy you're dead. We stream on BWTV, live on Facebook and on YouTube and all the other social media platforms. What I'll ask you to do is to really like the pages, click on the notification button so that when we put content out, you will be notified and you share that with other people. Then I would want to encourage you that when you go to any of our social media platforms, share the page. The detail will be there and we will be collating that. So at the end of the year, the Senior Partner Appreciation Award could be yours. Tiniduma over the weekend enjoyed that spa session with the partner, and I tell you, she you should have seen her excitement when she had that. And her friend that went to Ghana, Derek, is it Dixon or something, that went to Ghana, went to really had some good time there. And we have a new brother who's going to go to Ghana pretty soon to enjoy himself as well. So apart from you learning, gaining the experience and the knowledge, we will reward you at the end of the year. So you keep sharing, keep it going, and get people to appreciate that. And let's have a good part of the algorithm for our social media platforms. So until we come your way again for another edition of the Community and the Law, I want to once again say thank you to my friend, my brother. Somebody says I shouldn't say my learned colleague, but he's teaching me a lot. So definitely, he's learned and he's my friend. Thank you to Uncle Charles for having time to spend with us, and to the BWF Solicitors family, Uncle Ben, the senior partner, Lawyer Eunice, Lawyer Charles, Auntie Cynthia, Sandra, and all the wonderful people, the trainee lawyers and the staff both here in the UK and in Ghana. Our Lord Chancellor, the accountant whose birthday we celebrated not too long ago, to everybody, and to my studio producer, lawyer, well, I should call him lawyer, so he's here, Professor Ade, and to Sheila Ankara, my administrator, and then Padmo Dodu for all the aesthetics. My name is Oreku Sufrinpon. I wish you all the very best. We'll come again, same time next week. Until then, be good.